This podcast will deal with the Constitutional Convention, the type of government that was set up, the compromises that were made, and the debate over ratification. The Constitutional Convention that took place in Philadelphia was 55 of the nation's most elite and prominent men, all men of great education and great wealth. This made them very unrepresentative of most Americans at the time. Some of the men who took part were Alexander Hamilton, Benjamin Franklin, George Washington, John Adams, and James Madison, to name a few. They debated in private, and their records were not published till 1840. This is a picture of some of James Madison's notes. James Madison's notes were considered to be some of the most detailed notes that were taken at the convention, and much of what we now know today that took place behind those closed doors we know from Madison's notes. The delegates all agreed that the new government would have three branches: a legislature, an executive, and a judiciary. They also agreed that Congress would be able to raise revenue through direct taxes and not have to rely on state governments, something that hurt the Congress under the Articles of Confederation. But they debated about what this new legislature would look like. James Madison brought forth a plan known as the Virginia Plan. That would have two house legislature with population determining representation in both houses. This was favored by the big states because it would allow them to dominate the new Congress. The small states favored a plan known as the New Jersey Plan, in which there would be a one-house Congress with each state having one vote. Neither of these plans were accepted, and what took place is now known as the Great Compromise. Since we're from Connecticut, it's also known as the Connecticut Compromise because it was brought forth by two Connecticut delegates, Roger Sherman and Oliver Ellsworth. The Connecticut Compromise would be a two-house legislature, with the Senate being the upper house. The Senate would have equal representation. Each state would have two senators. The lower house, the House of Representatives, representation would be based on the population of a state. So, bigger states would have more representatives, smaller states would have fewer representatives. They agreed that senators would be chosen by state legislatures and would be elected every 6 years. The House of Representatives would be elected every 2 years and be chosen directly by the people of that state. Although the House of Representatives was an expansion of democracy, representatives were the only officials in this new government who would be elected directly by the people. The delegates assumed that officials would be chosen by the elite. Neither the president or federal judges would be elected directly. The president would be elected by the Electoral College or by the House of Representatives. The delegates did not trust ordinary voters to choose the president or the vice president. The two basic principles that make up the Constitution are federalism, or also known as the division of powers, and the idea of separation of powers, also known as checks and balances. Federalism is the relationship between the national government and the states. The Constitution strengthened national authority. The president was given the power to enforce laws and was made the commander-in-chief of the military. This new Congress would have the power to impose taxes, borrow money, regulate commerce, declare war, and deal with foreign nations and Indian tribes. States were not going to have the ability to print their own money as they did under the Articles. Also, things such as law enforcement and education, day-to-day activities of government were the duty of state governments, not the federal government. The Constitution also set up a separation of powers. This was done so that the Constitution was going to prevent any single branch of the new national government from dominating the other two branches. This is known as checks and balances, where each branch of government would be able to check the other branch's power. For instance, Congress enacts laws, but the president can veto them. And a two-thirds majority is needed in Congress to pass a law over a president's veto. Federal judges are nominated by the president and approved by Congress, but they have a lifelong term limit to ensure their independence. The president can be impeached by the House and removed from office by the Senate. Slavery sparked much debate at the Constitutional Convention. Although the words slavery and slave do not appear in the Constitution does have things about slavery. First, the Constitution prohibited Congress from banning the Atlantic slave trade for 20 years. In 1808, the first year that Congress could ban the slave trade, they did. But during that 20-year period, 170,000 new slaves were brought into the United States. The Constitution also required that states return fugitive slaves to their owners. And finally, a compromise was made at the convention known as the 3/5 Compromise. This said that 3/5 of the slave population in each state would count in determining the state's population for representation in the House and in the Electoral College. This gave the South the ability to dominate the new House of Representatives and gave the South more power in the national government than its free population should have had. Between 1788 and 1848, every president but 4 was a Southern slave owner. Some of those Southern slave owners were George Washington, Thomas Jefferson, James Madison, James Monroe, Andrew Jackson, John Tyler, James Polk, and Zachary Taylor. After the delegates approved the Constitution, was sent to the states to be ratified. Only 9 states needed to approve this new document, not all 13, as would have been the case under the Articles of Confederation. The states elected delegates for statewide ratifying conventions. These statewide conventions would be where people would debate whether or not to make this new document the law of the land. 2 parties formed a debate, the Federalists and the Anti-Federalists. The Federalists were led by Alexander Hamilton, James Madison, and John Jay. Together, these 3 men wrote a series of essays, 85 essays in total, that appeared in 1788, now known as the Federalist Papers. In it, they argued that the Constitution protected Americans' freedoms rather than endangered them. The Federalists were made up of the elite members of American society. The Anti-Federalists thought that their freedoms would be endangered by the power of the new federal government. They argued that the Constitution did not protect individual rights such as freedom of speech and trial by jury. They believed the new government would be dominated by the elites at the expense of ordinary Americans. The Anti-Federalists were made up mostly of struggling farmers and debtors and were very poorly organized. Once again, they argued that the Constitution did not protect individual rights such as freedom of speech and trial by jury. The original Constitution did not have a Bill of Rights. In order to win support for ratification, Madison promised that the first Congress would enact a Bill of Rights. It did. The first 10 amendments to the Constitution are now known as the Bill of Rights. The Constitution was ratified, but not before fierce debate in Massachusetts, New York, and Virginia. The last to ratify were Rhode Island and North Carolina. This map shows the ratification debate. If you look, the areas on the map in green are where the majority supported ratification. The area in purple is where the majority living there was against ratification. The area in pink is where people were divided over ratification. It also shows you the order in which states ratified. If you look, it only took 9 states to make it the official law of the land. But if you look at Virginia, Virginia was the 10th state, and New York was the 11th state. And in order for this new government to have any legitimacy, Virginia and New York were going to need to be a part of it.